So, good morning, ladies and gentlemen, from Qatar. I anticipate that there are people signing in from all over different time jurisdictions, from the Middle East, from Europe, and indeed from Asia. This is one of a series of webinars which Altamimi's construction team have been holding, and this one is specifically in relation to Qatar. With me today are colleagues from the Qatar team, my partner Hani Al Nadaf and Khushbu Shadapuri. All of us are based one time or another in Qatar, and we hope that today's webinar will be of interest to you, where what we're anticipating is something of a compare and contrast between the common law position in respect of certain issues that arise in construction contracts and how they might be dealt with under the Qatar Civil Code. So if we move on, the structure today is going to be very similar to the structure of those webinars that we've done previously, where it's a sort of presentation, an exchange of ideas in relation to the legal systems on the three topics that we've got there: conditions precedent, unjust enrichment, and good faith, and an opportunity at the end for any questions with our answers. Insofar as you do have any questions during the course of the presentation, please put them in the chat box and we'll endeavour to deal with them as we progress. So if we can then move to the first topic, which is condition precedent clauses. So these are a regular feature of construction contracts around the world, and perhaps by way of a starting point, what I was just going to deal with is a very standard one, which is found in the FIDIC suite, and specifically this clause, subclause 20.1 from the FIDIC Red Book. And it's a not unusual provision. This one has two parts to it. The first part is somewhat draconian in that what it clearly states is a time period within which a contractor is obliged to give any sort of notice, and the consequences of a failure to comply within that time period. So there will be no extension and no entitlement to additional payment, and the employer will be discharged. The second part is something less draconian in a sense, in that it does say that that there will be a taking into account of why there was any failure, and insofar as there is any actual prejudice suffered. However, and this is an important point to note in this particular clause, is that it is subject to the first paragraph that we've identified there. So what you have then is this concept of condition precedent. There is no entitlement unless a particular procedure has been followed. So the question is this or isn't this enforceable? So next slide, please. So in the context of the common law, there is significant case law which supports a very robust interpretation of these clauses. Certainly in the time that I've been practicing, this wasn't really the case. Certainly when I was in Australia, the Australians tended to take a much more aggressive stance. And then this has now been adopted within the UK. And you can see there that these two cases, which are relatively recent and illustrate the sense of it, that firstly, the Bremer Handel-Gesellschaft matter is really saying, what does the clause actually have to contain for the purposes of being enforceable? And that FIDIC clause is very complies completely with these requirements. So it's a precise time, and secondly, very clear language about what the consequences are going to be. And then the multiplex case really then provides some sort of substantiation as to why it is that such a clause ought to be enforced. And that is that what the draftsman is trying to do, and it's a very standard approach, is to require a contractor to, rather than to store up claims into the past, from the past, to then land them on the employer at the end of the job. What it's really requiring is a sort of an openness regarding what's going on, such that the employer is properly informed and is in a position to take steps, whether that's to continue with the requirement or indeed where it's an external event, to actually be in a position to address what the consequences for the project might be. So there we have it. That's the common law position. Now over to Hani in respect of what the Qatar approach may be.
Yeah, thank you, Andrew. Hi, everybody. Thank you for joining. Actually, just to start with general observation that I have noticed during my practice in Qatar. It has been around now 14 years I'm working in Qatar in this particular field of construction. The issue that most of the stakeholders and practitioners in the construction are coming from different jurisdictions, and even the contracts, the project managers, the lawyers, the claim consultant, they are coming from different backgrounds and they are working under the governing Qatari law, which creates many challenges to everyone, to the non-Qatari lawyers, as well as to us being able to adapt and to transfer the knowledge of the law. So this resulted in very big dilemma too, actually. One related to the concept, the difference in concepts between the civil code and the common law, and second, in terms of terminology. And this condition precedent is one of the obvious example of concept and terminology, and you will see now as we go how this is translated in the construction contract. So condition precedent, as Andrew explained, is the condition that need to be fulfilled in order for the contractor to make a claim, whether extension of time or prolongation cost or otherwise. The condition precedent, the equivalent or the translation of condition precedent in Qatar leads us to totally different concept. So if we translate, so the concept of condition precedent as none under common law does not exist as such under civil code. And this is one. So here you have entitlement, a contractor has entitlement to claims, and there is an agreement that the contractor doesn't have the right to make a claim unless he sends a notice of 20, for example, in this case, 28 days. Otherwise, he will lose the right to make a claim. So in principle, as you can see, there's the famous Article 171 of the Civil Code. It states that the contract is the law of the contracting parties, i.e. whatever the parties agree in their contract, this will be the law. And provided that this agreement doesn't contradict or violate the public orders in Qatar or the mandatory provisions. And this is when, again, another big difference between the civil code and the common law. So not everything you put in your contract would be enforceable. And this condition precedent may and may not be, I will come to this, but many other provisions in the construction contract may not be enforceable under the mandatory provision of the civil code. So in principle, the condition precedents should be enforceable because it is an agreement. Now, is this enforceable, or does this provision contradict the provision of the mandatory law in Qatar? There is no clear-cut answer to it. This is arguments the Qatari court has not opined on this point particularly, and therefore we have, as a law firm, we have acted for both employer and contractor, and sometimes at the same time. So we make an argument to support the condition precedents and plead the enforceability of it in one case, and the next day we make totally different argument to support that this is not enforceable. Unfortunately, we don't have clear answer. Even in our arbitration cases, we have two cases where we won based on the fact that this should be enforceable and binding, and in two other cases we found a award saying that this is not enforceable because it contradicts the public order in Qatar. And this will explain it more in the next slide, please. So the mandatory provision, you will have heard hopefully of the famous Article 418 of the Civil Code, which state that it should not be possible to agree on limitation for a period other than those specified by the law. So what we are, this condition precedent in one of the way to interpret it, it said that the contractor will not have the right to go to court and claim his entitlement, contractual dues, unless he sent the notice within 28 days. Otherwise, his claims will be time barred. And this, if we read Article 418, we have pleaded one time successfully in a big arbitration that this provision of condition precedent is not binding because it contradicts the provision of 418. And indeed, the arbitration tribunal accepted this, and they didn't apply the notice requirement, being a barrier on the contractor to claim his extension of time and the prolongation cost. Now, on another side, there is another argument which plead that no, this is enforceable and this should be accepted. And maybe we missed in the previous slide reference. No, it's one here. No, it is there is a requirement under the Civil Code itself of notification, which said, could you please just go back a little bit just to, yes, this Article 686 of the Civil Code, it has a similar meaning of the condition precedent or the notice requirement. So this is why we have a very good argument pleading in this direction and very good argument pleading in the other direction. So please go next slide, please. Again, a next slide. So to this point, I sorry to say that there is no certainty on what's the right position to be taken, but definitely there is good argument in the two directions. And it depends on how the tribunal or the court will look at it until the time when we hear from the Court of Cassation in Qatar to decide whether these provisions are enforceable or not. So at this point, as I will hand it to Khushbu to give you what the latest development on this point. Khushbu,
thanks,
please.
Hani. Good morning, everyone. So Hani and Andrew have spoken a little bit about the civil and common law approach to notice requirements with respect to entitlement to claim clauses that are frequently present in FIDIC contracts. Building up on what they have both discussed, I'm just going to touch a little bit about the practical aspects of this clause. Sorry, Joe, can we just go one slide back? Just the previous one. Yeah, this is great. So in our experience, whether this clause, these notice requirement clauses are part of a contract that's governed by either the civil or the common law jurisdictions, as far as arbitration matters go, what we have seen tribunals generally tend to do is to interpret these clauses in a way that's reasonable, logical, and fair in the circumstances of the case. And this flexibility that gives tribunals a degree of latitude around the harsh consequences of enforcing strict time limitations in certain jurisdictions is actually reflected in one of the clauses of the FIDIC contracts, albeit in the context of dispute adjudication boards. So what you see here is clause 20.1a of the Gold Book, which is used in design, build, and operate clauses. And it says that if there are circumstances which justify the late submission, and if the DAB considers that these circumstances of the late submission are acceptable, they have the authority to override the 28-day limit and advise both parties accordingly. This approach really reflects the inherent flexibility that a notice requirement clause actually entails. So the obligation on the contractor to give notice of its entitlement to a claim as soon as practicable, or as soon as he became aware or should have become aware of the event or circumstances giving rise to the claim. I mean, that in itself is such, it has both an objective and a subjective criteria. But before we address that, it's worth to highlight that claims, or how claims are actually defined in the construction sector. So construction scholars have defined claims as being nothing more than a crystallization of an anticipated but not yet specified part of the contract price. And this in itself is a really interesting definition of a claim because it alludes to all events or circumstances giving rise to a claim as being already anticipated by the employer. And arguably, this is one of the underlying reasons for notice requirements, that is to put the employer notice of any possible event that could give rise to a legal claim by the employer. So just moving on as to when notices are to commence. A typical FIDIC contract would impose either a 14 or 28-day notice requirement from the date when the contractor became aware or should have become aware of the event or circumstance. So as I alluded to previously, so there's both a subjective and an objective element in this clause. And because of this subjectivity as to when a notice could be considered a late submission, and when this late submission could be acceptable is why tribunals generally tend to adopt a flexible approach with notice requirements. So why could and should a late notification be considered acceptable? I mean, there are a variety of reasons. And some of our cases that we have been involved in, what we have seen, reasons that the contractors put forward for late submissions include either the contractor not realizing that the event or circumstance had occurred, or although the contractor realized that this event or circumstance had occurred, it didn't realize that this particular event or circumstance could give rise to an entitlement, either because they didn't understand the contract, the underlying law, or they didn't realize the true nature of the event or circumstances. So a couple of concrete examples of this that we have seen is in cases where there have been a number of design changes or revisions initiated by the employer. They have caused underlying variations, EOT, additional payment claims. Another common scenario that we have seen tribunals accept is when informal notices have already been given to the employer, say in project meetings or through email exchanges. So as long as there's a sort of contemporaneous element, tribunals generally tend to accept that notice has been met. So we're now just going to move on to unjust enrichment, and I'm going to hand it back to Andrew to discuss the common law perspective of this. Thanks.
So, hi, thanks, Khushbu. When we were considering this this webinar, in many ways, what we're talking about, and we've divided into the three sections of conditions precedent, unjust enrichment, and good faith, you could possibly see as all one. But in fact, it is worthwhile teasing it out as we have, because all three are linked, as they would be if the Qatar law is being applied by a court or indeed by arbitrators. And these next two sections, in a way, are actually looking at this same aspect of conditions precedent, and I think where we've got to is to in terms of a summary at this stage, is that in the common law jurisdictions, it is generally much more likely that a condition precedent clause is going to be enforced. In the GCC, and then in Qatar in particular, there are grounds for enforcing conditions precedent, but equally there seem to be there is more room for actually stepping outside of the black letter of the contract. And what we're now looking at is some of the bases on why that might be the case. So unjust enrichment, if we go on to the next slide, please, just to touch on this from a common law perspective. So the broad point to be made here is that the history of the English common law is such that really the parties are held to their bargain, and there is very little around the edges to alleviate them from what it is that they've agreed. However, there is a tradition within certainly English law, which is called equity, which is then linked in many ways with some of the principles from the GCC. But it is of a very narrow application. And what I've just set out here are some of the principles in the way in which unjust enrichment might be used in a common law context. And this flows particularly from a concept of what's called restitution, which is it's sometimes called a sort of quasi-contractual remedy. I won't go into all of the detail there, and certainly we're happy to share these slides subsequently. But one area where the concept of restitution regularly arises in the context of construction contracts is where a bond has been called, and certainly in the GCC in Qatar, bonds are, I think, much more frequently called than they might be in the UK, possibly because a lot of them are on-demand bonds. The question then arises, which is, insofar as a party has called a bond, and the allegation is that they should not have called that bond, how does the bondsman, or how does the contractor get his money back? And the remedy is it one of, in the common law at any rate, is of restitution and unjust enrichment, because as we all know, it may well be that the conditions or non-conditions in an unconditional bond mean that the bond, in one sense, hasn't been unlawfully called. The party was entitled to call on the bond, but the real question is, but are they really entitled to hang on to the money? And that then has to be substantiated. But it's not a contractual claim in respect of getting that money back. It is one in relation to restitution. And so it is that is possibly the one area where the concept of unjust enrichment applies, whereas actually in the GCC, unjust enrichment may arise in many more cases. And so I'll hand over to Hani now, next slide, for a discussion about unjust enrichment.
Yeah, thank you. So the same concept, but different application, as we said. So the unjust enrichment, we call it in Qatar enrichment without cause, and or enrichment without legitimate cause or legal cause or lawful cause. And whether this is the same concept or not, again, sorry, this is a big question. But in general, this Article 220 of the Qatar Civil Code, it says clearly that every person who enriches without a just cause on the account of another person is liable within the limit of what he enriched to compensate that person to the loss he has suffered. So this is, and as we heard from Andrew, approximately this is the same principle of the unjust enrichment. However, under the civil code, there are like different source of obligation, including the contract and the law and the tort. And one of these is the enrichment without cause. And the courts in Qatar and in the region and all the scholars are of the view that when there is a contract, the contract will be the sole source of obligation. So between the contract between the employer and the contractor, there is no room to rely on the unjust enrichment. You have to rely solely on the contract provisions. And this is why this is important to say in the context of the condition precedents also, there will be an argument to say that the contractor have fulfilled all his obligations and he completed the work and he made even the variation, blah, blah, blah. And now the employer has enriched on the account of the contractor, and yet because the contractor missed to send the notice within 20 days, then he will not be able to claim the cost or the delay related cost or any disruption or extension of time. So this is, in a way, it's under the common law and the standard. You can't plead that the employer has been enriched on the account of the contractor, and hence this can be recovered under this arguments. In Qatar, we have seen this actually. This is why this is important to have this comparison. We have seen this argument pleaded in many cases, and obviously by the other party, as we explained that, and we brought all the authority to prove that you cannot rely on the concept of unjust enrichment under clause 220 in the context of contractual relationship. So this is again another evidence or proof that the concepts are there. It's the terminology, it's important, and the difference in the concepts, it's extremely important. However, this is not to say that the civil code doesn't entertain or doesn't aim to just or fair treatment, because I think it's not the same, but it might be close to the enrichment, the unjust enrichment, is the concept of abuse of right under the Qatari law, which we will come to it in a while. Just the bottom line that legally speaking, purely legal speaking, reliance on unjust enrichment in the context of contract, especially construction contract, to make any claim, this is not 100% legal, and it's not acceptable under the civil code. So next slide, please. Now,
so over to me there, I think.
To Andrew, he will just take you through the last.
So I think where we're getting to here is that in this use of the English language phrase unjust enrichment, there are similarities between the common law approach and the and that of Qatar, in that there is a remedy, but it's of quite limited scope in the context of construction contracts, and that really you have to find some other legal principle for the purposes of being able to bring that sort of claim. And that brings us on to this concept of good faith. And if we go on to the next slide, please. I've advised clients all over the world, and it often is an uncomfortable thing to be saying as a practitioner of the common law, that there is no concept of good faith in English contract law. It's almost as if you're saying that there's an encouragement of bad faith, but that's definitely not the intention. The difficulties which the commercial law of England has always had with the concept of good faith is that it simply does not provide certainty between the parties. And of course, certainty comes at something of a cost. And the cost is that if the contract is the contract of the parties and that will be enforced come what may, then there may be some injustices there. But on balance, the position has been taken that there is more benefit in certainty than there is in having the introduction of a general obligation in relation to good faith. However, that doesn't stop the parties incorporating into their contracts a concept of good faith if that's what they choose to do. It's rare. However, it's always useful, I think, for any of us who are involved in the construction industry to see an example of where in common law there is a concept of good faith, a contractual concept of good faith, and how it's been interpreted. And a standard form contract that is very, very heavily used within the UK, it is also used internationally, but to a lesser extent, is this form called the NEC, or New Engineering Contract. It's now in its fourth edition. It's been around for over 25 years. And all of the editions have had this obligation right at the very beginning of the contract. I'll read it out. The employer, the contractor, the project manager, and the supervisor. So the two parties to the contract are the employer and the contractor. The project manager and the supervisor are appointed by the employer, shall act as stated in the contract, and in a spirit of mutual trust and cooperation. And over the years that the NEC has been used, this has caused all sorts of problems. But there have been a couple of recent cases, admittedly on an earlier edition, but the wording is essentially the same. And the court came to a conclusion that even if you've got this obligation of good faith, that doesn't prevent you from operating the contract to your own advantage. Now, that I think is quite an interesting take on the way in which the concept of good faith might be interpreted in a more general sense if it ever did come up in another contract. And it's really, I suppose, going back to the original position in the English common law, which is the parties have agreed on their terms, and those terms will be enforced as they are drafted, and they won't be ameliorated in any way by a suggestion that a party ought to be looking out for another party. So with that rather sort of aggressive 18th, 19th century approach to common law, I hand over to Hani on the next slides in relation to how good faith is looked at in Qatar.
Yeah, thank you, Andrew. So again, the good faith indeed does exist, and it's provided for under Article 172 of the Civil Code. And it's stated that the contract must be performed in accordance with its content and in a manner which is consistent with the requirement of good faith. So this is the general requirement that should apply to all kinds of contracts, including obviously the construction contract. And again, this is again related to the condition precedent and other points in the sense that, and I personally think this is a good argument, in the sense that if the contractor has performed his work perfectly, and he did bring the resources, entertained all the delay, make investment in completing and bringing the source, although with a long period of delay, he should not be penalized by the only fact that he couldn't, or he failed to send a notice within 28 days. So if he sent the notice in not within 28 days, in 30 days, so after he delayed 2 days, is it a good ground for the tribunal to dismiss his claims on the basis that no, you didn't comply? Is this a strict compliance with this notification? I don't think so. And this is exactly where the principle of good faith, or very linked, the abuse of right. Although you have the right, clear right under the contract to say that I am released from any liability if I don't receive the notice within 28 days. And hence, despite the effort and the fact and the cost deployed by the contractor to complete my project, yet I'm not going to accept his claims because he was delayed 1 week or 2 days. This is acting in bad faith, definitely, and this is abuse of right. If you can see, this is a very, very well-established concept under Article 63, which says that the exercise of right should be unlawful, even if you have the right under the contract or under the law. You cannot use this right unlawfully. If you want the interest to be achieved is unlawful, obviously. If it was only intended to cause damage to others, maybe number 3 is more relevant to the condition precedent. If the interest to be achieved is at all disproportionate with the damage inflicted on others. So if you didn't suffer damage because of this 2-3 days of delay or 1 week or 2 weeks, yet the contractor has suffered a huge damage and incurred a lot of expenses in your project, and yet you use this 28 days notice requirement to dismiss the claim. I think there is a ground, and I would say it's a good ground to rely on the good faith and abuse of right to dismiss this reliance on the notice requirement. So this is a very good concept, does exist, and it has many application under the civil code. Could you please go to the next slide? Yes. So these are the example of the abuse of right. For example, where the loss of an entitlement to claim is disproportionate to the loss suffered by the party to whom notice ought to be given, a court or tribunal is entitled to consider the reliance on the notice requirement as abuse of right. So this is what I explained to you. So as I said, we don't have a precedent, a specific judgment confirming that this is possible in the context of notice requirement. However, the concept is there, it's recognized, and there is a good definition of the abuse of right, what is the elements and conditions of the abuse of right, and definitely this can be used by the contractor in the context of the notice requirement. Please, next slide, Joe. Now, this is there is a possible application. This is, as I said, we can see this in the practice what the main issue that we have dealt with regarding the condition precedents and relevant to the good faith and enrichment without cause. So the first one, as a use of condition precedent to deny otherwise valid entitlement. This is, as I said, this is a sort of abuse of right. The second one, denying claims where the employer is the cause. So this is a different argument. So the delay in sending the notice was not possible for many reasons. And this is where the practice and the factual element will come into play. So the employer was causing the incapacity of the contractor to send the notice a timely manner. For example, sending design without a proper justification and the change in the design. We have seen this in one case where every time there is change of design, there is no markup. So the contractor should start from scratch, and so this will lead us to the other point when the 28 days will start. And this is very important. This is factual. So what we are trying to highlight here, the factual debate between the party, which in my opinion, in most of the cases, the factual point will be the conclusive and the important points in determining whether the notice requirement would be accepted or not. So one of the points that has been again discussed heavily, the point about the rationale behind the notice period, and why the party agreed to in the clause that you should the contractor should notify within 28 days. What is the rationale? Is it in principle under civil code because the employer doesn't want to end it up after 1 or 2 years having a huge exposure in terms of the time and cost, and therefore he's entitled to get the money, to get the notification about the progress of the work and the potential extra cost that he may incur. And therefore, this is very reasonable, reasonable clause to protect the employer. However, if this rationale has been met, or if there is no, if the delay didn't affect the employer, didn't cause damage to the employer, is it still possible to rely on the notice? So why we agreed the notice? We didn't agree the notice for the sake of preventing the employer, the contractor. It was a rationale to protect the employer. So if the employer was not affected, can he still rely on this 28 days? This is another element. And this notice requirement, it has been again discussed in many cases in Qatar, but not in the context of the claim or the condition precedent, but in the context of termination. And whether this notice, termination notice, is it enforceable or not enforceable under Qatari law, which this is a totally different debate. So at this point, I don't know whether Andrew or Khushbu, you want to add something on the...
I think we're... So next slide, please. I think we've come to the end of the slides. So it really is then just a couple of questions. I mean, we're there or thereabouts in terms of timing. I mean, just to perhaps touch on one of those points that Hani's addressed there regarding good faith in respect of termination. Again, my own experience working in the GCC is that employers are much more prepared to operate the termination provisions in construction contracts than they are in other jurisdictions. And the allegation is repeatedly made after the exercise of that sort of clause, termination clause, that the termination has been made without good faith. And undoubtedly, the article which requires a party terminating to go to court before terminating is one which does actually put a brake on the ability to terminate in a way that almost is the court giving itself the opportunity, or the civil code giving the court the opportunity to check whether indeed there has properly been an exercise of good faith in those circumstances. So I know we've had a few questions in. I mean, Khushbu, are you able to just feed those?
So I mean, there were some questions from the audience which were quite interesting. Someone has asked whether tribunals have or could accept notices given informally. So, for example, where there was a statement recorded in meeting minutes, and without then following it up with a formal notice, how would this be accepted by the tribunal? I mean, I think the underlying ethos is what we all discussed: good faith and reasonableness in issuing notices to the employer. But maybe, Hani, if you want to take a first go at this question, that would be great.
Yeah, this is actually related to the point that I made earlier. So why the party agreed? So what's the rationale behind this requirement? So if we have a concept under the civil code which say that if the intended purpose has been achieved, then you cannot rely on the invalidity. So there is no form under the law, specific form to send the notice. Even if sometimes there is a format in the contract, but if the the contractor can prove that the intended purpose has been achieved, i.e. the employer became aware of this, of the delay event, whether it is through notice or through a minute of meeting or otherwise, I think the tribunal should accept this.
Yeah, I've often said this in these webinars and indeed to clients, and in many ways it doesn't actually matter what legal system you're in front of. No legal system is going to want to see injustice done. Now, that's a very broad statement, but invariably, even with the harshness, some would see it, of the common law position in respect of the enforcement of conditions precedent, where a party has in some way satisfied what's the underlying intent behind the clause by informing the employer, for example, that there has been some delay, but it may not comply quite completely with what are the contractual requirements. Invariably, a tribunal is going to try and find a way to give some sort of credit to the contractor in those circumstances. Now, how they do that may very much depend upon what the facts are, but you could easily see that they might say, well, yes, this does satisfy the requirements. Even if you were being particularly rigorous, you might say it hadn't. Alternatively, they might actually then see this as an argument to suggest that the particular clause isn't a condition precedent. Or, and this is one that every party to a construction contract needs to be alert to, where neither party has really been complying with the strict procedures under the contract, there is every reason then to suggest, and whether this is argued under the GCC rules relating to unjust enrichment or enforcement of conditions precedent or good faith, or whether it's argued under common law argument of waiver, that if neither party has been bothering to comply with notice procedures throughout the course of the contract, a tribunal may turn around and say, well, they agreed that they wouldn't need to do this. But my concluding remarks in relation to that question are, read the contract at the beginning, understand what the procedures are that you're supposed to comply with, and save yourself any of these arguments and comply to the way in which, to the best of your ability during the course of the contract, irrespective of what the law is that applies to your contract. Save yourself the hassle. Khushbu, any others?
We have another question, I think.
More.
Yeah, maybe one more. So someone has asked, from a contractor's perspective, whether or not the civil code requirement to get a court order before a contract can be lawfully terminated should be excluded. So maybe Andrew, if you want to take this, and then we'll pass it on to Hani as well from his perspective.
Hey, my own experience in the GCC is that generally the parties do take the step of excluding the requirement to go to court to be entitled to terminate. Sometimes that's not reciprocal. Sometimes it's the contractor has to go, but the employer doesn't, because more often than not, the terms and conditions are those of the employer. I think there is some benefit, I think, in terms of avoiding any sort of rush to terminate. But more often than not, I mean, parties, even though in the GCC there is a willingness to terminate more than in other jurisdictions in which I've worked, that step is never taken lightly. Hani?
Yes, quickly. Obviously the civil code requires any termination to be done through the court, and the party doesn't have the right to unilaterally terminate and decide who's right and who's wrong by themselves without the supervision of the court. So this is a principle, and this principle is, however, the party can agree, but it should be very clearly stated that the contract will be terminated without court order in case of breach. So this is possible, but the language of the contract should be very, very clear. And this is obviously, academic discussion, because in practice, it's totally different. And this point, the very legitimate legal point, in practice is not really observed, or no one will look at it before terminating. So this will not usually, in our experience, taken into consideration in the decision of terminate or not. But this is a long discussion that maybe will require a separate webinar, the termination, the legal termination, and the ground and the consequences of illegal termination. This may require another webinar.
Well, maybe, I don't know, Khushbu, any other questions?
I mean, there's a related question to the termination of a contract, which, I mean, it's a sort of a loaded question, really. I mean, I'll ask it and we'll see the extent to which we can answer it. What must a contractor do to be able to claim damages for a termination of a contract? And obviously, I think this question presupposes that it's an unlawful termination, which entitles the contractor to damages.
Hani, yeah, you want to go first?
Thank you. So this is if there is illegal termination, i.e. the illegality consists of the fact that the employer or the contractor didn't seek court order, so the termination was done through notice without court order. This is, in principle, as I said, this is theoretical or academic discussion. It's illegal, no doubt. Now, what the consequences? The consequences is that if you terminate illegally, the contractor will go to court or to arbitration, and they will prove that the termination was illegal. By the time the court, the case is done, the project is completed and maybe a new contractor took place. So there is no ground to claim that to reinstate the contract or come back to site because it will be practically not possible. So the claim would be compensation. The contractor should have the burden to prove that this first illegal termination, i.e. that there was no court order, and even it's not enough because he should prove that he didn't commit breach justifying the termination. But if for the sole reason that I was wrong, I wasn't performing, I have been doing everything wrong, but because the employer didn't seek court order, this will render the termination illegal. I don't think any tribunal will accept this. It might have some consequences, minor consequences, but the most important, as I said, whether there have been breaches or not. This is the illegality. The notice is important, but not so important in practice, unless, and this is important, unless you have time to seek injunction and to stop the termination and get order saying that this termination should be suspended and the contractor should come back to site, i.e. they would call it that specific claim, specific performance of the contract. So this is different context. I haven't seen this in practice, but in theory, it is possible.
Yes. I think it again, irrespective of the legal system, insofar as you are looking to claim damages as a consequence of the other party's behavior, you're going to have to prove that behavior, A, was a breach of contract, and B, that you have actually suffered damages as a result of that breach. And it's not specifically on this point, but I think it's worth mentioning in this context, and that is that very, very often I've had contractor clients come to me where they have been terminated, and they've been looking then for what they perceive to be their profit on the job. But of course, that's got to be proved, and it's got to be proved in relation to the work that they have been unable to carry out as a result of what's alleged as being an unlawful termination. And yeah, it's interesting what you say, Hani. I think even if there is, in a technical sense, an unlawful breach because there's been a failure to go to court to get the requisite authority from the court, actually, what that process is there to protect the contractor from is from an exercise of a termination which is in breach of obligations of good faith.
Yeah. Yeah.
But if in fact the contractor is in breach and there would have been an entitlement to bring the contract to an end, but for this failure to follow the procedure, well, you know, no legal system is going to be granting you any damages in that context. Okay, so I think let's wrap it up for today. I mean, thank you very much, everybody, for taking part. We've slightly gone over, but just to say, this was one of a whole series of webinars that we're doing in relation to construction issues across the region, and then specifically in relation to particular jurisdictions. And obviously, this one is in Qatar, and we'll be doing further ones. Insofar as you do want the slides, please let us know. And insofar as you've got any ideas about other topics that you may want us to discuss, please let us know. We'll do some sort of formal follow-up through our business development and marketing team. And on that note, thank you very much to co-presenters Hani Al-Nadaf and Khushbu Shadapuri. And we'll see you next time. Thank you.
Thank you.
Thank you.
Thank you.
Bye.
Bye-bye.
Bye.